Hello, this is Wajahat Ahmed. I'm a visiting faculty at OP Jindal University. I'm recording this module on behalf of Professor Y.S.R. Murthy. The module is about freedom to manage religious affairs, a study of Article 26 of the Constitution of India. The intended learning outcomes of the module are: it introduces students to the relevant provisions in the Indian Constitution, which lay down the framework of making India a secular state while at the same time ensuring guarantees for religious freedom and its practice. The students would learn about Article 25, 28 of the Constitution, highlighting the concerns of religious discrimination, matters of religion, and who is a minority. The preamble of the Constitution, containing the intentions and ideals of the Constitution makers, declares that people of India have solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic. The expression socialist secular was added to the preamble by an amendment in 1976 with an object to spell out expressly the high ideals of socialism, secularism, and the integrity of the nation. Although India is a secular state, but it cannot be considered as an anti-religious state, because the Constitution guarantees the freedom of conscience and religion. The concept of secularism adopted and practiced in India is quite different from the American concept of secularism, which requires complete separation of church and state. Though Articles 27 and 28 contain some specific prohibitions, there are other provisions in the Constitution of India which are inconsistent with the theory that there should be a wall between church and state. Article 25 to 28 reflects the Constitution's sui generis approach to secularism, religious issues, and the rights of minorities. These articles, divided in two chapters, illustrate the unique equilibrium of the Indian Constitution on these three issues. These articles also manifest an unusual amalgam of individual and collective rights. Article 27 and Article 28 emphasize the secular nature of the state, as these two provisions secure to every person freedom from the payment of taxes for the promotion of any religion and freedom from attendance at religious instruction or religious worship in certain educational institutions. Article 25 guarantees to every person the freedom of conscience and the free profession, practice, and propagation of religion, while Article 26 guarantees to every religious denomination or a section of it a right to manage its own affairs in matters of religion and the right to establish and maintain institutions for religious purposes. Article 26 thus guarantees collective freedom of religion subject to some limitations. It guarantees to every denomination or a section of it the right to establish and maintain institutions for religious and charitable purposes and to manage in its own way all affairs in matters of religion. This provision also provides rights to such denomination or a section of it to acquire and own movable and immovable properties and to administer such properties in accordance with law. This module seeks to focus on freedom to manage religious affairs as provided under Article 26 of the Constitution of India. This module will introspect on the concept of religious denomination and various rights provided to it under Article 26. This module will further explore relation between Article 26b and Article 26(2)b. Module also looks into the complications which surface due to legislative regulation of management of religious endowments. Religious denomination, meaning and scope. As stated, right provided under Article 25 is an individual right, whereas the right guaranteed under Article 26 is the right of a collective group like the religious denomination or any section thereof. Neither the term religion nor denomination has been defined under the Constitution. However, Supreme Court in the Sri Shirur Mutt case, speaking through Mukherjee J, adverted to the meaning of the word religion found in the Constitution of India. Thus, the word religion has not been defined in the Constitution, and it's a term which is hardly susceptible of any rigid definition. Religion is certainly a matter of faith with individuals or communities, and it is not necessarily theistic. There are well-known religions in India like Buddhism and Jainism which do not believe in God or any intelligent first cause. A religion undoubtedly has its basis in a system of beliefs or doctrines which are regarded by those who profess that religion as conducive to their spiritual well-being. But it would not be correct to say that religion is nothing else but a doctrine or a belief. A religion may not only lay down a code of ethical rules for its followers to accept, it might prescribe ritual and observances, ceremonies and modes of worship which are regarded as integral parts of religion. And these forms and observations and might extend even to matters of look and dress. Further, a denominator has been defined in Shirur case by the Supreme Court with reference to the meaning of the term in the Oxford Dictionary as a collection of individuals classed together under the same name. Now almost always specifically, especially a religious sect or body having a common faith and organization and designated by a distinctive name. It has now been established through various judgments that three conditions must be satisfied in order to qualify as a religious denomination under Article 26. These are, it must be a collection of individuals who have a system of beliefs which they regard as conducive to their spiritual well-being, that is common faith, B, common organization, C, designated by distinctive name. Therefore, members belonging to different religions satisfying the three tests would be a denomination within the meaning of Article 26. The expression denomination can also be used for members forming sects or subsects of a religion designated by a distinctive name. Pertinent to note that unlike Article 30, benefit of Article 26 is not confined to minority groups only. Sikhs not in minority in Punjab constitute a religious denomination and can thus claim the benefit of Article 26. Establishment and maintenance are under Article 26A. Every religious denomination has a right to establish and maintain institutions for religious and charitable purposes under Article 26A. The words establishment and establish and administer must be read conjunctively, and therefore, where an institution has been established by a religious denomination, it can claim the right to maintain the same as well. In other words, a denomination has no right to maintain an institution until and unless it has not been established by it. This phrase was also discussed in the Aziz Basha case, where it was held that Aligarh Muslim University has been established under a statute and not by the Muslims as such. Therefore, they cannot claim the right to maintain the same. Court noted that the right under Act 26A will only arise where the institution is established by a religious denomination, and it is in that event only that it can claim to maintain it. Court further stated that since Aligarh Muslim University was not established by the Muslim minority, therefore no question arises of its right to maintain it within the meaning of Article 26A. Management of religious matters under Clause B. Clause B confers on a religious denomination or a section of it the right to manage its own affairs in matters of religion. This right can be taken away only if it runs counter to public order, health, or morality. The term matters of religion used in Article 26B is synonymous with the term religion in Article 25(1). It includes not only religious beliefs but also such religious practices and rites as are regarded to be an essential and integral part of religion. With regard to the scope of the term matters of religion, it has been held by the Honorable Supreme Court in Durga Committee, Ajmer versus Said Hussain Ali, that in order that the practices in question should be treated as a part of religion, they must be regarded by the same said religion as it is essential and integral part. Otherwise, even purely secular practices which are not an essential or an integral part of religion are apt to be clothed with a religious form and may make a claim for being treated as religious practices within the one meaning of Article 26. Court further noted that even practices, though religious, may have sprung from merely superstitious beliefs and may in that sense be extraneous and unessential accretions to religion itself. In the light of these observations, court held that unless such practices are found to constitute an essential and integral part of a religion, their claim to the protection under Article 26 may have to be carefully scrutinized. What constitutes an essential part of a religion or religious practices has to be decided by the courts with reference to doctrines and tenets of that particular religion. An interesting issue came before the Honorable Supreme Court in Sardar Sayyidina Tahir Saifuddin Sahib versus State of Mumbai. The petitioner, who was the religious head of the Dawoodi Bohra community and trustee of its property, challenged the constitutional validity of Bombay Prevention of Excommunication Act 1949 on the grounds that it violated its fundamental rights guaranteed under Articles 25 and 26 of the Constitution. This act invalidated excommunication of members of any community. Court, after examining the provisions of the Act, held that the expression laws providing for social welfare and reform in Article 25(2)(1) of the Constitution was not intended to enable the legislature to reform a religion out of existence or identity. The activities referred in Article 25(2)(a) are obviously not of the essence of religion, nor was Article 25(2)(b) intended to cover the essentials of a religion which are protected by Article 25(1). By taking away the power of excommunication from Darul Mutlaq, by which he kept the denomination together and maintained the purity of fellowship, the impugned court held the impugned act contravened Article 25(1) of the Constitution. However, minority view was that act was a measure of social reform justified by Article 25(2)(b). However, this pronouncement is subject to criticism that it prefers the denominational right over individual freedom of conscience guaranteed under Article 25. It can also be argued that Article 17 abolishes untouchability, and position of an excommunicated person is very much similar to that of an untouchable, thus protected under Article 7, harmonizing Articles 25(2)(b) and 26(b). On a combined reading of the Article 25(2)(b) and 26(b), we find an inconsistency. Article 25(2)(b) provides for social welfare and reform or the throwing open of Hindu religious institutions of a public character to all classes and sections of Hindus, while under Article 26(b), the term matters of religion include religious practices which signify such questions all as who are the persons entitled to enter into a temple for worship, what they are entitled to stand, how worship is to be concluded, are all matters of religion coming within the purview of Article 26(b). Therefore, it means that a denomination has a right to exclude persons from participating in the worship under Article 26(b). In order to harmonize these two provisions, the question which arises is whether the right guaranteed under Article 26(b) is subject to a law protected by Article 25(2)(b). In order to resolve this issue, court in Sri Venkataramanna Devaru versus State of Mysore held that the right of a denomination to wholly exclude members of the public from worshipping in the temple, though comprised in Article 26(b), must yield to the eventual right declared by Article 25(2)(b) in favor of the public to enter into a temple for worship. But while the right claimed is not one of general and total exclusion of the public from worship in the temple at all times, but of exclusion from certain religious services, they being limited by the rules of the foundation to the members of the denomination, then the question is not whether Article 25(2)(b) overrides that right so as to extinguish it, but whether it is possible so to regulate the rights of the persons protected by Article 25(2)(b) as to give effect to both the rights. If the denominational rights are such that to give effect to them would substantially reduce the right conferred by Article 25(2)(b), then of course on our conclusion that Article 25(2)(b) prevails as against Article 26(b), the denominational rights must vanish. But where that is not the position, and after giving effect to the rights of the denomination, what is left to the public of the right of worship is something substantial and not merely the husk of it. There is no reason why we should not so construe Article 25 to be as to give effect to Article 26b and recognize the rights of the denomination in respect of matters which are strictly denominational, leaving the rights of the public in other respects unaffected. Based on the above submission, the highest court ruling in favor of Gauda Saraswat Brahmins held that during certain ceremonies and on special occasions, only members of their community are entitled to participate to the exclusion of all others. Therefore, the discriminational right has been recognized for what is left to the public of its right under Article 25 2b is substantial. Another very interesting issue came before the court in Sarwar Hussain and others versus additional civil judge and others. The issue before the court was whether a Mohammedan belonging to a particular sect has an absolute right to demand that the imam of his sect would lead him to prayers and restrain others from preventing him for offering the prayers as desired by him. Court, after reviewing the literature on the issue, held that court ruled that a public mosque is a place of worship for the Mohammedans, and regardless of their sect or denomination, or as to who had founded the mosque, they are entitled to offer their prayers in the mosque. It's a fundamental right of every Mohammedan to offer the prayers in a public mosque. He cannot be denied this right on the ground of not belonging to a particular sect or denomination that have founded the mosque or were managing the said mosque. Court further noted that the fundamental right of a Muslim in a mosque is to offer the prayers. What particular right will be followed and how it shall be done are matters of practice. This cannot be termed to be a fundamental right in the exercise of religious rights. Acquiring and administering the property. Clause C and D of Article 26 provides to a religious denomination the right to acquire and own property and to administer such property in accordance with law. A distinction has to be made between administration of property as mentioned in Clause D and managing religious affairs as provided for in Clause B. While the former can be regulated by laws which the legislature can validly make, the latter is a right which is subject to public order, morality, and health. No legislature can take away. In the landmark case of Ratiala Panchand Gandhi versus State of Bombay, court made some significant pronouncements on the scope of Article 26D. Court noted that the language of the two clauses B and D of Article 26 would at once bring out the difference between the two. In regards to affairs in matters of religion, the right of management given to a religious body is a guaranteed fundamental right which no legislation can take away. On the other hand, as regards administration of property which a religious denomination is entitled to own and acquire, it has undoubtedly the right to administer such property, but only in accordance with law. This means that the state can regulate the administration of trust properties by means of laws validly enacted. But here again, it should be remembered that under Article 26D, it's the religious discrimination itself which has been given the right to administer its property in accordance with any law which the state may validly impose. It's to be noted that Article 26D is the fundamental right of religious denomination to administer properties in accordance with law, and the law therefore must leave the right of administration to the religious denomination, itself subject to such restrictions and regulations as it might choose to impose a law which takes away the right of administration altogether from the religious denomination, and vests it in any other secular authority would amount to violation of the rights guaranteed by Article 26D. In Durga Committee versus Hussain Ali Durga Khwaja Sahib Act 1955, which vested administration of property attached to the Dargah and in a nominated community, was challenged on the ground that the committee would include persons other than the Chishti Muslims, which was unconstitutional. Court held that since in the instant case, the Chishti Sufis never had any right of the management over the Dargah, endowment for the centuries since it was created, the argument of unconstitutionality of the Act must fail. Court noted that Article 26C and D do not create rights in any denomination or its section, which it never had. They merely safeguard and guaranteed the continuance of rights which such denomination or its section had. In other words, if the denomination never had the right to manage the properties endowed in favor of a denominational institution, as for instance by reason of the terms on which the endowment was created, it cannot be heard to say that it has acquired the said rights as a result of Article 26C and D, and that the practice and custom prevailing on behalf of which obviously is consistent with the terms of the endowment should be ignored or treated as invalid, and the administration and management should now be given to the denomination. Such a claim is plainly inconsistent with the provisions of Article 26. In Khajamian Waqf Estate versus State of Madras and others, court noted that it was next urged that by acquiring the properties belonging to religious denominations, the legislature violated Articles 26C and D, which provide that religious denominations shall have the right to own and acquire movable and immovable property and administer such property in accordance with law. These provisions do not take away the right of the state to acquire property belonging to religious denominations. Those denominations can own, acquire properties and administer them in accordance with law. That does not mean that the property owned by them cannot be acquired. As a result of acquisition, they cease to own that property. Therefore, their right to administer that property ceases because it is no longer their property. Article 25 does not interfere with the right of the state to acquire property. Supreme Court, however, has restricted this right of acquisition by holders that if acquisition of property of a religious denomination by the state can be proved to be such as to destroy or completely negate its right to own and acquire movable and immovable property for even the survival of a religious institution, the question may have to be examined in a different light. Court has also noted that what is the reasonable regulation by state must depend on the nature of the fundamental right sought to be regulated, the purpose for which it is conferred, and the general pattern of constitutional rights and obligation. It must also depend on the directive principles enumerated in Part 4 and the socio-economic structure envisaged by the Constitution, that in the event of conflict between the individual right and legislation implementing socio-economic policies laid down in Part 4, greater weight should be given to the policy enumerated in the directive principles. Another case which needs mention here is the Dr. M. Ismail Farooqi versus Union of India, where the Honorable Supreme Court considered the question of acquisition of religious place by the state court, held that a temple, church, or mosque, etc. are essentially immovable properties and subject to protection under Article 25 and 6. Every immovable property is liable to be acquired. Court further noted that there can be no reason to hold that a mosque has a unique or special status higher than that of the place of worship of other religions in secular India to make it immune from acquisition by prerogative power of the state. A mosque is not an essential part of the practice of the religion of Islam, and namaz by Muslims can be offered anywhere, even in open. Accordingly, its acquisition is not prohibited by the provisions in the Constitution of India. Irrespective of the status of a mosque in an Islamic country, for the purpose of immunity from acquisition by the state in exercise of the sovereign power, its status and immunity from acquisition in the secular ethos of India under the Constitution is the same and equal to that of the places of worship of other religions, namely church, temple, etc. It is neither more nor less than that of the places of worship of other religions. Obviously, the acquisition of any religious place is to be made only in the unusual and extraordinary situations for a larger national purpose keeping in view that such acquisition should not result in extinction of the right to practice the religion. If the significance of that place be such, subject to this condition, the power of acquisition is available for a mosque like any other place of worship of any religion. The right to worship is not at any and every place, so long as it can be practiced effectively, unless the right to worship at a particular place is itself an integral part of that right. Relying on the above observations, Gujarat High Court has justified the acquisition of a mosque in the public interest for widening the road. Reiterating the observations made in Ismail Faruqi case, the High Court noted that the protection under Article 25 and 6 of the Constitution is to religious practice, which forms an essential and integral part of the religion. A practice may be a religious practice, but not an essential and integral part of practice of that religion. While offer of prayers or worship is a religious practice, its offering at every location where such prayers can be offered would not be an essential part of or integral part of such religious practice, unless the place has a particular significance for that religion, so as to form an essential or integral part thereof. Places of worship of any religion having particular significance for that religion, to make it an essential or integral part of the religion, stand on a different footing and have to be treated differently and more reverentially than the other places of worship of that religion. Now let's sum up. We began by highlighting the diverse nature of Indian secularism and its incorporation in the Indian Constitution. While discussing the scope of Article 26, we noted that benefit of fundamental right is not confined to minority groups only. Further, we explored the meaning of the term religious denomination under Article 26. Through various case laws, it has now been settled that the three conditions of common faith, common organization, and designated by distinctive name has to be satisfied in order for a community or group to qualify as religious denomination. We further saw that under Article 26A, a denomination has no right to maintain an institution until and unless it has not been established by it. We also looked at the term matters of religion used in Article 26B is synonymous with the term religion in Article 25(1), and it includes not only religious beliefs but also such religious practices and rites as are regarded to be an essential and integral part of religion. We also emphasize on the application of doctrine of harmonious construction by reading Article 25(2)(b) and Article 26(b), subject to another by the Honorable Supreme Court, highlighting the distinction between Article 26(b) and 26(d). We noted that as regards administration of property, which a religious denomination is entitled to own and acquire, it has undoubtedly the right to administer such property, but only in accordance with law, meaning thereby that state can regulate the administration of that property, of trust properties, by means of laws validly enacted. The regulation can only be in respect of the administration of this secular part of the religious endowment and not of beliefs or practices which are integral part of the religious belief or faith. We come to an end of the module. Thank you very much.